Thank you. Mr. Safar?
Yes, Your Honor. Good morning. Madam Chief Justice, and if it please the Court, my name is Aziz Safar, and I appreciate the opportunity to appear and argue on behalf of Richard Howard. At issue in this case is whether a DSS social worker's action of questioning an arraigned defendant at a jail outside his attorney's presence violates the Sixth Amendment right to counsel. The defendant answers that it does. Department social workers do hold official privileges.
Mr. Safar, I don't wish to cut short your argument, but my reading of the Commonwealth's case, I'm not alias the Commonwealth, but essentially, for these purposes, the Commonwealth has all but conceded that there was a violation of the Sixth Amendment right, and so I think it would be very helpful if you could address most of your argument. You can use it any way you want to, but most of your argument to the harmless beyond a reasonable doubt or automatic reversal.
And is that the standard that the Court would want me to focus on as opposed to structural error?
Well, that's why I said either structural error or harmless. In other words, which standard should we be using from your point of view, and depending on which standard, how would you like to guide the Court? You can, of course, address the substance of the first one, but I think in light of the Commonwealth's brief in this Court, it might be better to look at the remedy. Yes, might be more useful to us to look at the remedy.
Well, the manner of her interrogation and the impact of her interrogation, our position is, did undermine the trial proceedings and do warrant review for structural error. It remains unclear why the defendant spoke with this social worker in the first instance.
I have a fact question. Did the caseworker interview the defendant previously as a member of the same team?
She previously interviewed the child witness, but not the defendant, as far as I'm aware in the record.
Does the record tell us whether there had been any prior involvement with DSS prior to this case by the family?
There is a peculiar connection. There is an indication that the defendant was in his own child custody battle. And that may be even an inference as to why he decided to speak with this social worker.
And that's in our record?
Yes, it is. That's in the record. It's footnoted in Judge Roop's findings of fact that the defendant was undergoing child custody proceedings in the probate and family court.
You said that the Commonwealth allowed...
You're saying he was undergoing a custody proceeding that DSS was involved in? That's my question.
Yes. Yes, the DSS was involved in that proceeding.
And they were giving reports in that proceeding?
And the inference, Your Honor, would be that perhaps that is why he opted to speak with this social worker in the first instance, hoping for some type of department leniency in those custody proceedings. But going on to this question...
well, excuse me, I have another question for you. You say in your brief, I think, that the Commonwealth allowed the caseworker to take the defendant's statement while she knew that it could be used against him. But in fact, didn't Trooper DeSin write a letter to the DSS that the caseworker should not make any contact with the defendant?
Well, Your Honor, the point is that she, in light of that, she did make contact.
But it isn't that the Commonwealth allowed it. It's as if she went out on a frolic of her own.
I understand your concern, but it goes both ways. If they really did not want to have this go forward, they should not have gone through all the trouble to use it at trial. They could not have this both ways. On the one hand, and say, we don't want you to use it, stay away from it, and then effectively endorse it by pushing it into the trial, and it infected the trial.
Mr. Safar, could I just ask you this? You have raised claims only under the United States Constitution.
That is correct, Your Honor.
In Satterwhite, the United States Supreme Court said that in cases like this, we look at whether the error is harmless beyond a reasonable doubt. Okay?
However, we have cases that also in our Commonwealth that have interpreted the Sixth Amendment. For example, Commonwealth versus Manning, that discuss egregious conduct to the point where this court even dismissed the indictment with prejudice. But just a few more points on this structural error. Moisiers not only sought the defendant out, she also helped form the impetus behind prosecuting the defendant. She was on the same team, obviously. She informed law enforcement about his family court appearances and that, in her opinion, he was a risk of flight, after which he was arrested. And her actions were also egregious in kind because, despite the fact that her investigation period had expired, her regulatory investigation period had expired, she still went out and actively sought him and posed questions to him only on the issue of his guilt. So the exact impact, really, of the defendant's statements cannot be measured because under these circumstances, at the time that this occurred, would impact many things such as the possibility to engage in plea negotiations, defendant testimony, or even an alibi. So there were some things that were impacted that undermine the trial mechanism itself. I'll move forward now to discuss harmless beyond a reasonable doubt.
Could you, in that connection, Mr. Small, could you address in particular your claim relating, or the evidence relating to the problem with the DNA evidence because of consanguinity?
Yes, Your Honor. And even under a harmless error standard, the Commonwealth is still required to meet a heavy burden of showing beyond a reasonable doubt that the evidence did not make a difference. And again, I would just remind the Court, not that without the evidence the verdict would have been the same, but that beyond a reasonable doubt it did not make a difference. And the DNA evidence here was questionable because of the defendant-complainant blood relationship, which impacted the weight the jury would attribute to that evidence. On the other hand, the defendant's statement was different in kind. As an admission, it certainly carried great weight with the jury. And the content of the statement directly impacted the timeline of November 5th and spoke to the aggravated form of the offense. The DNA evidence merely supported paternity. It corroborated contact, but was completely silent on the timing and on this issue of the aggravated form of the offense.
Why was it such an important statement? He was related to her, right?
That is correct.
And all he said, as I understand it, and correct me if I'm wrong, please, was that he had seen her 8 or 9 months before the baby was born. Is that right?
That's correct. Yes.
So why is that? I mean, I can understand it's somewhat inculpatory, but
her allegation was that she was not only statutorily raped, she was forcibly raped on November 5th, and that is the timeline. And there are many things here that impact or make uncredible or discredit this complainant's testimony. In our brief, we cited that given the ordinary course of gestation, conception would relate back to on or around October 20th, 2001, not November 5th. So his statement clearly impacts that timeline. Also,
his statement was that he saw her
He saw her 8 to 9 months, and it clearly impacts this timeline of November 5th.
But just that he saw her.
Well, that he said he was in contact with her. And what inferences the jury would draw from his own admission? That remains unknown. But again, the standard is on the government to show that beyond a reasonable doubt, it did not make a difference. So it's phrased in the active that they have to show that.
Well, we look at all the evidence.
Yeah. Was there any evidence evidence in this proceeding that she had a boyfriend at the time she became pregnant?
Yes, there was.
Okay. Well, that's why I'm saying what were the words that he saw her?
Your Honor, essentially it was an admission from him that
I understand you're characterizing it as an admission, but what did the admission say?
That he was in contact with her 8 to 9 months prior, which puts him right smack in her presence at the time of the alleged rape. Okay.
You know, I'd like to just go back to something we talked about before.
Yes,
the big picture.
Yes.
He's got an ongoing custody matter in which DSS is investigating.
Correct, Your Honor.
If a party doesn't cooperate with DSS in an investigation, and then DSS reports on their failure to cooperate, sometimes negative inferences can be drawn from that.
That is correct, Your Honor. And that was the whole point of why would he speak with her? Okay, he was not the most savvy or intelligent person, granted.
And she knew that.
And she knew that, correct. Why would he speak with her? Why? The inference is there that he was in custody proceedings an ongoing battle for the custody of his daughter, and here comes somebody from DSS. And in a sense, an argument could be made that this also interferes with the attorney-client relationship, shakes confidence in his attorney, because maybe she could give him something his attorney could not. And that runs to the other proceedings.
Well, that was certainly not something that's in the record. I mean, there's no record that this discussion was, look, if you tell me what you really did here, we'll take care of the other case. I mean, there was nothing of that sort in the record of this case.
Absolutely, Your Honor.
As opposed to Manning, where the agents were saying, you cooperate with us, forget about your lawyer, we'll take care of you. He won't.
Yes, Your Honor. But again, we're dealing with somebody who had a 7th grade education, borderline issues, and she approaches him. She seeks him out at a jail.
Mr. Safari.
And she doesn't tell him that anything he says could be used against him.
That's correct, and that's why there can be no valid waiver. The waiver could not be intelligent without that specific clause.
Mr. Safari, is the Commonwealth correct in its brief here that the evidence at trial, the DNA evidence, established that the defendant was the father of the victim's child?
Again, that assumes that the jury ascribed the proper weight to that evidence. They had their own expert come on and say, well, there is sharing of types because they're directly blood related. There is sharing of types. However...
Well, the Commonwealth has made a representation to the court, and I'm just asking you whether you agree with it. I haven't looked at the record. The DNA evidence established that the defendant was the father of the victim's child. Is that correct?
Is that what the expert testified to?
That is what the expert testified to.
Did you have a contrary expert?
No.
Or whoever
There was no...
defended this fellow?
Well,
isn't that the end of everything?
No, it is not.
Did the defendant deny having had any sexual relationships with this woman?
Well, there were two theories, essentially, that were offered. Was that it never happened the way she said it happened.
Well, it's the difference between it never happened the way she said it happened.
Correct. So when he says that, then I think that speaks to the element of force. So in a sense, the defense theory, if you look at the record, the tenor of the record says that the defense theory was a bifurcated theory. That one was, okay, it didn't happen, period. And then there was another one that said, well, it wasn't forcible. And the issue of force, and this was part of the initial argument that we had submitted in terms of the Alifar, and we focused on this issue.
But how did he express the opinion, or his view that it never happened at all? How was that expressed by the defendant?
Okay, and that was brought up through defense witnesses. There was an issue with a seat in a car that supposedly, according to the complainant, it flips down very quickly, and he brought on
But was there any evidence that the defendant himself had
defendant
denied that it happened outright?
Well, the defendant did not testify. So, and I don't recall any admissions, any backdoors coming in, any words coming into that effect. But what there was testimony with regard to the car that it didn't happen in the forceful way that the complainant depicted, because the seat of the car had to be rotated incrementally rather than drop down. Also, there was an issue where the defendant said on November 5th, and this came through as an admission to Trooper DeChisholm, he said he was in Maine on November 5th and was not.
Mr. Safar, what was the thrust of the defense closing argument? What did the attorney say?
Well, the attorney said that it didn't happen. It wasn't forcible rape.
Does that mean he conceded that they had what he considered to be consensual intercourse?
Well, maybe the trial attorney could have been a little clearer on this, but it seems like they split it up. In other words, they were saying
it didn't happen, but
it didn't happen, but if it did, it wasn't forcible. Yes.
Then, in that context, how can a statement that I had contact with her 8 or 9 months ago be very harmful?
Well, it is, Your Honor, because...
I mean, if the defense argument is that it happened, but it didn't happen in the way she says it happened, his statement is just simply consistent with that defense, it seems to me.
Well, Your Honor, the statement would run to the aggravated form of the offense. because it corroborates what the complainant said, was it was a forcible rape on November 5th.
How does the statement I had contact with her 8 or 9 months ago corroborate force?
Well, that's when she says it happened, and it bolsters her credibility.
But I thought you were telling me that in the closing argument, the defense attorney argued that it didn't happen that way.
Right, well, it didn't, his argument was it didn't happen at all, right? However, as a corollary, another step to that, the attorney said, or introduced these elements that it may not have been forceful. But the main thrust of the argument was that it didn't happen at all.
Thank you, Mr. Safar.
Okay, thank you.
Mr. Greenbaum?
Good morning, Your Honors. If it please the Court, I'm Stephen Greenbaum for the Commonwealth. The Commonwealth does, Your Honor, Chief Justice, you're correct. The Commonwealth, in a sense, concedes that this likely error, and without going too far, why the Commonwealth suggests the Court need not decide it. One factor is that the interview and the motion hearing in this case occurred roughly 2 years before the decisions in Atkinson and Hilton came out, which are what bring us here. And the focus of that hearing was really strictly everyone's understanding, albeit perhaps incorrect of the law at that time, is that this only applies to police or their agents, and that was the focus of the defendant's motion. That was, in fact, the focus of the argument before the appeals court. So that I would suggest the inquiry by the court, the trial court, perhaps doesn't flesh out these issues in a way that this court has sufficient information to make a decision or any blanket rule regarding the status of DSS workers.
Are you saying that this is no longer a problem with DSS? I mean, do we
No,
have to
I
write
agree. There should be a concern if DSS interprets the Atkinson case as saying their workers
they can't in the way
have carte blanche to go ahead.
They cannot. I mean, how can they possibly do
Well,
that?
I
No, I don't believe they can. But
I guess what I'm driving at is, do we have to write a big essay about the whole thing, or can we just say in words or substance that you concede error, which is what you're doing, right? Well, are you going to tiptoe up to it or tiptoe around it?
Well, concede that it's likely error. I'm not sure the court
All right,
has
likely
sufficient-
error.
Yes,
And,
it could have.
Okay, well, likely error, yeah, okay.
But I would also suggest that the Atkinson, which seems to be one of the cases that was a concern and why this was, Atkinson and Hilton, I don't think are necessarily at odds, although in Hilton, there's a footnote in Hilton indicating the court, the mixed results in terms of other statuses of workers.
So what you are saying is we've got to write an essay on it because the DSS may not know what they're supposed to do.
I think that is a concern.
Well, I have to say, in the light of Hilton, I find that extraordinary because Hilton makes quite clear that once the Sixth Amendment right to counsel is attached, which is unquestioned in this case, the Messiah line of cases broadly prohibits, quote, government efforts to elicit information from the accused. The Commonwealth is the Commonwealth. There's no question what the social worker was doing here. Now, what happens, for example, before, you've got the right to counsel is attached, or there's a real, here's the man, they've stopped the sane interview. There's no question in this case. We can make that clear, but it seems to me that Hilton disposes of it. Let me ask you, though, if you can address first, just explain to me why, in light of this record, I understand the usual Satterwhite thing, but why in the light of this record, where the conduct of the social worker, seems rather out of the ordinary, we shouldn't go to Manning?
Oh, yes, I would say the Manning and the cases that Manning relies on talk about, I believe, situations in which the fundamental relationship between defendant and his counsel is poisoned.
So it's the interference with the right to counsel, not the fact that there's counsel and then somebody else does something.
That's correct. Not simply an error like this. And in fact, this court, how the conduct in Manning was described as a deliberate and intentional attack by government agents on the attorney-client relationship in a calculated attempt to coerce the defendant.
I saw Manning, but that's essentially and all the other lines of cases.
The other lines of cases involve conflict of interest.
Okay, assume that. Go ahead.
May I ask you your position on the fact that there was this other custody case that DSS was involved in? And what is a person to do when they know they've got an ongoing case in which DSS is making regular reports, and then they're confronted by DSS and it's asked some questions. Now, the questions didn't relate to the ongoing custody case, but on this new charge. But wouldn't you say that a person would feel compelled to respond and to answer the questions because of fear of the negative inferences that might be drawn in the open case?
I suppose that that's an inference that could be drawn. There's nothing in the record that indicates that this issue was raised during the interview. There's nothing in the record that indicates that the defendant claimed this was. But even if that were the case, I don't believe that should change the standard of review for what happens for the remedy for this error. It would just be further reason to indicate why this was error.
She's asking him about this case.
Yes, and she says it's for the interest of the child, and I believe her narrowly driven focus is, well, I've got a 51A, I've got to decide whether to support it, and her ultimate conclusion is, oh, the 51A allegation is supported. I would suggest that an arrest of a defendant on the sexual assault charge is sufficient to support it. You don't need to go and interview him.
Not only, I mean, if there's any question, we have to write an opinion that says you cannot do that.
But that is perfectly, the Commonwealth has no quarrel with that. And
if some social worker does that, the district attorney cannot then use that evidence.
Well, at the state of the law at that time, certainly just in this case.
I'm just saying if there's any question.
It should be suppressed.
Mr. Greenbaum, assuming that we find that this was an error and apply the standard of harmless beyond a reasonable doubt here, what is your best evidence that this was harmless beyond a reasonable doubt? In other words, briefly summarize your best case.
There are two pieces of evidence. Look, we can assume for the sake, on the basis of the jury's verdict, number one, that they credited the testimony of the victim, the conviction there. I don't know that that's relevant, but they did credit her testimony and convicted him of this crime. As to the issue of this evidence, the statement was his last contact. It was not his last contact with the victim, he said, was 8 or 9 months earlier, approximately. And this was at a time approximately 2 weeks after she had given birth to the child. Two main pieces of evidence. The DNA evidence, the statistics, the way it was reported was that the results were 21 million times more likely if the defendant was the father of the baby than if a random male was.
What about consanguinity?
The expert, Mr. Mannix, was specifically asked about that, and there was a reference to a thing called type sharing, but his specific response was that it would have no effect on his calculation, on his statistics or his conclusion.
Okay.
So that, and the defendant did not challenge that on cross-examination, did not present an expert to make any suggestion that because this was an uncle-niece relationship, that a conclusion that he was the father.
Okay, so you had the victim's testimony the way it happened, you had the DNA evidence,
and you have one more piece of testimony. The DSS social worker who was working on the defendant's case involving him and his daughter, a social worker named Jennifer Knowlton, testified that she had set up and had a home visit with the defendant on November 7th, 2 days after the on or about date that this crime occurred, in the home where all these people lived on November 7th, that at that time his daughter was enrolled in the local schools, that she became aware the daughter did not withdraw from the local schools till December 1st, so that that information alone can draw an inference that any suggestion that the defendant was out of the state around the time of the rape was unlikely. A jury can infer that he was around at the time of the rape.
Okay, so maybe the evidence that a statutory rape had occurred was overwhelming. But if we were to conclude that the evidence of force had not been established to the point that it was harmless beyond a reasonable doubt, taking into consideration what the testimony that was offered by the social worker, if the case has to be retried, does it have to be retried on the entire indictment, or can it be tried only on the issue of force?
That's a question I had not considered. One of the arguments in the underlying appeal, the defense counsel asked for a lesser included instruction on statutory rape, non-forcible rape, and that request was denied by the judge at trial, and the decision of the judge was upheld by the appeals court. The only evidence that this wasn't consent, the defendant's son testified, in addition to testifying that his father was in Maine in November when this happened, he testified that 2 to 3 months prior to the trial of the case. He was at a family party, and according to him, the victim had said it wasn't rape.
Do you agree with defense counsel's characterization of the defense as one of outright denial that it occurred, or do you think that the defense was that it was not forcible rape?
The evidence presented, I couldn't tell you. To me, there was no coherent defense. The defense was
What's the closing argument? What's the closing argument?
The closing argument is you can't believe the victim because of this car seat thing. But every time that gets brought up, it drives me crazy because the evidence the defendant presented that the car seat had a different kind of lever than she described was presented by an investigator who supposedly came up with the car and the registration belonging to the aunt who owned the car. She conceded on cross-examination that the registration of the car that supposedly was used did not match the car that she said had a different lever. In fact, the car they presented there, this was bogus evidence. So that would have carried no weight with the jury, in fact, negative weight, because it would appear that what are they trying to do here? So the car seat is nothing. There's no evidence of consent. This is DNA evidence. So
there was no theory.
The theory was, well, she originally, for a long time, the victim had suggested that her boyfriend, a man named Eric, was the father. And her testimony was she did that because she was ashamed that she had been impregnated.
Well, that's out the window because of the expert.
Right, and that went out the window because of the expert.
So the defense was what we call
But the closing argument was really an attack on don't believe the victim. But I don't think, because he wasn't going to get a lesser included instruction on statutory rape, he just said, don't believe her, like you get the car seat, why did she say her father was there? There was no focused, I think, argument. I don't believe there was any precise concession.
It was a hope and a prayer.
I agree. There was no reason.
What was the evidence of force that was offered?
The victim's statement.
The victim's testimony.
Yeah.
One of the things that concerns me in this sort of analysis of whether the error here was harmless beyond a reasonable doubt is the following. The testimony that was elicited from the investigator, the DSS investigator, that we at least seem to be in agreement upon was not appropriately obtained, was put into evidence in rebuttal. Rebuttals aren't often used unless it's an important issue that the Commonwealth thinks needs to be rebutted. And so that in and of itself gives me pause about how important the Commonwealth felt this little bit of evidence might have been.
I can't speak to the tactical decisions of the prosecutor in this case. I believe it was a response to I believe the only testimony regarding this, well, there had been testimony in the direct case that the defendant had told the police he was in Maine in November. And the defense case, one of the witnesses was the defendant's son, who did state that my father and I, we went up to Maine, with the daughter, went up to Maine in November, and then on cross-examination it was November and December. I don't get the dates right. So just to rebut the claim that the possible inference they were trying to ask the jury to draw that he wasn't around when she became pregnant and the rape happened, that's why this was put on rebuttal. I assume that's the tactical reason for it. I don't believe this, given the state of the other evidence, to me it clearly wasn't necessary to the case. But it's hard, anyone who's been a prosecutor, you're not going to tell a prosecutor, oh, you've got enough evidence, don't use that. You've got enough for your case. No prosecutor is going to not use evidence that appears to be admissible and might help the case. I don't believe this did.
Sometimes more is less.
Sometimes. But I don't think in this case. If there aren't any other questions, there were some questions about the record. I'm wondering if I touched upon all those. I talked about the car seat. Some question, some claim about the defendant. The defendant there was no denial there was no testimony from the defendant, no denials one way or another. There was nothing that came before the jury as far as evidence.
Well, he didn't take the stand.
He didn't take the stand. The only statement of his was this, I had last contact.
And the police, presumably. He said he made statements to the police.
Statements to the police, but they weren't, attempted exculpatory statements to the police. I don't believe I have anything else. If the court has any other questions.
Thank you, Mr. Greenbaum.
Thank you.
I'm out the next week.